Good afternoon, all. I'm just going to wait a few more minutes as is usual, or maybe 90 seconds, just to make sure we have everyone in the room and we have our live stream working. All right, I believe we have everyone in the room. I've been informed our live stream is a go. So welcome everyone, good afternoon. Thanks for joining me in the afternoon instead of our usual morning. My name is Nicole Kinsey. I'm a hearing officer with the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference for Phase 1A of the hearing on the pending petitions of Consolidated Irrigation District, Fresno Irrigation District, Alta Irrigation District, and Semi-Tropic Improvement District of Semi-Tropic Water Storage District to revoke or revise the declaration of fully appropriated stream systems with respect to the Kings River system on a potential revocation of water right licenses 11517 and 11521, and on a proposed cease and desist order against the Kings River Water Association and its member units. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording and the Zoom generated transcript, which I recommend to you because it's sometimes amusing, but it is helpful, to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If you are experiencing technical difficulties trying to communicate with us during this pre-hearing conference, please send an email to the AHO at admin, ADMIN, HRG office at waterboards.ca.gov. Our staff will be monitoring the email inbox and we will work with you if we have problems. As usual, assisting me today are several staff of the Administrative Hearings Office: Nicole Mullen, Amy Blunk, Megan Nyes, Skylar Anderson, and Kyle Wooldridge. I'd like to go ahead and move to appearances. I know we all know each other at this point, but we'll take care of that and just identify everyone who's here. And we'll work through as usual. First, I'll ask for Semi-Tropic Water Storage District. Typically we have Mr. O'Brien. Are you here with us today? Or an alternative?
I believe Mr. O'Brien is on mute. This is Sam Bivens for Semi-Tropic Water Storage District. I'm joined by Kevin O'Brien.
Sorry, Kevin O'Brien also with Mr. Bivens, and Mr. Bivens will be taking the lead for us this afternoon.
Thank you, and I'm sorry, Mr. Bivens. I know you, and I just didn't have you in my notes. I apologize. Kings River Water Association, Mr. Hughes.
Yes, Ms. Kinsey. Joe Hughes on behalf of Kings River Water Association, and also with me, also on behalf of Kings River Water Association, is Leonard Herr.
Great, thank you. And I apologize, I have Mr. Herr in my notes as well. I believe we're calling them the Upper Irrigation Districts. Is that right? Alta Consolidated and Fresno Irrigation District.
Good afternoon, Ms. Kinsey. Nick Jacobs representing Alta Consolidated and Fresno Irrigation Districts. And I see Jeff Boswell, General Counsel for Fresno Irrigation District, is here as well. And I don't know if any of the other general counsels are here.
I had in my notes, sometimes Ms. Lane joins us, but no need. I'm sure we'll see her again soon. Tulare Lake Basin Water Storage District, Mr. Keel and or Ms. Moritzen.
Good afternoon, Ms. Kinsey, Peter Keel, and I'm also joined by Ms. Moritzen. Thank you.
Great, welcome, thank you. The McMullen Area Groundwater Sustainability Agency, Mr. Donlin.
Good morning, Ms. Kinsey. I'm joined today by Shonda Grady.
Thank you. Welcome. Ms. Spalletta, on behalf of all of your clients, are you here joining us today? There you are.
Good afternoon, Ms. Kinsey. Jennifer Spalletta.
Thank you. People's Ditch Company, Last Chance Water Ditch Company, Mr. Richardson.
Good afternoon, Ms. Kinsey. I am here on behalf of Peoples and Last Chance.
Thank you. Good afternoon. Mr. McLaughlin for Terra Nova Ranch.
Ms. Quincy, this is Zach Smith. I'm appearing for Terra Nova Ranch today.
Thank you, Mr. Smith. And then Ms. Miller from the California Department of Fish and Wildlife.
Good afternoon.
Good afternoon. Thank you. And in some of the email contacts I have, you may have seen it, they're all uploaded to the FTP site. There was an inquiry from the State Water Board's Office of Enforcement. So I did want to ask whether we have anyone with the Water Board's Office of Enforcement joining us today.
This is Kenneth Petrozelli here for the State Water Board Office of Enforcement.
Great. Thank you, Mr. Petrozelli. I'm glad you could join us. And I will get to this issue. I'll go through the agenda, but we will have this issue of whether or not Mr. Hess is going to be a witness. It's in my notes as something to get to. So thank you for being here. Is there anyone else on the line who would like to, plans on participating and would like to identify themselves? All right, thank you. I'll go ahead and get started. The purpose of this pre-hearing conference is to address procedural issues related to phase 1A of the hearing. And I have, I think, it looks like I have 7 agenda items for today's conference. They're relatively small, and I'm sure some of you may have other issues to raise. First, I'll just go through those and we'll get started. First, I wanted to address any issues that may have come out of the April 23rd pre-hearing conference order that my office issued. Second, I'd like to talk about hard copy exhibits, the submittal process going forward. I realize there's been some, it may have been a little difficult to get those in, and I apologize. I just wanted to talk about that going forward to make it a little smoother. Third, the order of proceeding for the hearing. I thought that would be helpful to talk about, what to expect. Number 4 are the additional hearing dates, and then the timing of the rebuttal portion of the hearing, both respect to those dates and the first 3 days that we have had scheduled for a while, and how we might work that to proceed smoothly. Number 5 is whether the Upper Irrigation District's plan to call Damon Hess as a witness and how his appearance is going to be coordinated. Number 6, any other procedural issues that anyone may have and care to raise today. And then finally, whether or not we should schedule another pre-hearing conference before we start the hearing itself on June 2nd. So I'll start in with the April 23rd pre-hearing conference order. On April 23rd, I issued that order along with a notice of additional hearing dates. That order set time limits for summaries of direct testimony, but I do want to note that we did receive the amended NOI from the McMullen area GSA indicating their intent not to present direct testimony, but to otherwise fully participate in phase 1A of the hearing. So that's noted and does change the estimated amount of time for direct testimony somewhat. The order also directs the parties to submit second amended NOIs by May 17th. And those amended NOIs should list the rebuttal witnesses or anticipated rebuttal witnesses. And then also, if you would please identify your panels of witnesses that you propose for purposes of cross-examination. And I think I'd ask the parties to identify either 1 or 2 panels, probably 2. And if you really think 3 is more appropriate, then please propose that. Any form for that is fine. I realize our standard NOI form doesn't really account for these 2 issues, so please feel free to submit that information in the form you feel most appropriate to convey it to us. So I appreciate that. The order also sets the afternoon of June 17th and then all of June 18th as additional dates for this hearing. And I do want to talk about those dates, the timing of rebuttal, and make sure we work out any issues, if there are any, related to witness appearances and attorney availability for those dates. But we will get to that a little bit later. Other than discussing the additional hearing dates and times and rebuttal, which we will get to, are there any other issues related to the April 23 or addressed in the April 23rd pre-hearing conference order that you would like to, any of you would like to raise now? And there'll be another chance if you think of something later. Great, then let's move along. I did want to address the hard copy document submittal. I realized when we had that May 3rd deadline and the most recent deadline of yesterday for some updated additional exhibits, that there may have been some challenges getting the hard copies to us, and I apologize for that. It's partially because this is a new office and we're working out our procedures, and partially because of course, the COVID emergency. So most of us are not in the office, plus as I understand it, the public are not being allowed into the Cal EPA building. So what I'd like to do or propose going forward, we have the rebuttal deadline of May 26th when all of you will be submitting, or not all of you, some of you may be submitting additional exhibits. We will have AHO staff in the office on that day, and they in the afternoon, starting in the afternoon, when you may be, if you choose to, walking over hard copies of the exhibits, and they will be available to receive those. Please just email admin@waterboards.ca.gov and coordinate with our staff on the day or the day before as it's convenient, and we'll just make sure that someone is available to receive those documents, and so things will run a little more smoothly. There's no need to work through our water rights records unit. I think coordinating with our staff will be hopefully more streamlined going forward, so I did want to mention that. And then if you submit your documents by the deadline through the FTP site and then mail the hard copies, I think for the rebuttal exhibits, because it is close to the hearing dates, I'd appreciate an overnight of the exhibits, but that's fine. We'll consider the mailed copies to be timely, of course. And if you have those FTP submittals in and your proof of service, that works fine too, instead of walking the copies down to our office. I appreciate your patience on that. Is there anything, any questions or anything else to comment on submittals of the hard copy documents? Well, thank you again, and thanks to your executive staff or support staff for working with us on having no one in the office, which is sometimes challenging. Next on my list, we're moving right along, is the order of proceeding. I wanted to talk through how that might go. It seems we're getting close enough to the hearing that it's appropriate. What I am envisioning is that we would start the hearing on June 2nd with opening or policy statements from any party who will not be putting on a case in chief. If you opt to make a policy statement or an opening statement, that would be the time. And then I would see us moving straight to Semi-Tropic's case in chief. First, hearing summaries of the testimony. I think we do this by panels of witnesses. So if there are two panels for Semi-Tropic, we'd start with the first panel for the summary of direct testimony and then move to cross. And then we would go to the second panel and then move to cross. And now that I'm thinking about it, if there's redirect, I think we would do that immediately after the cross-examination. So once those witnesses are done and are excused, their testimony is complete for purposes of the case in chief. And then at that point, after Semi-Tropic's case in chief, we'd move on. I assume it would be KRWA or the upper irrigation districts. I'm going to ask for your input on that. Who would like to go first? And then what I envision is probably Tulare Lake Basin, and then last Terranova Ranch. And then I would call the parties for purposes of cross-examination in roughly that same order, unless there's a reason to move things around. Are there any comments on that order of proceeding? Am I missing something? Are you thinking of something that will make this run better? Anything that you would like to add on this point? Mr. Jacobs, I see a hand, please.
Yeah, I don't know. I'm just thinking here whether the panels are more helpful to you or whether or not it would be more helpful to you to have cross immediately after the witness.
I think the panels, frankly, I think the panels of cross run, in my experience, they've run more smoothly. Especially when you have testimony that's really related in subject matter. So a particular question may actually be directed to more than one party, so you effectively aren't duplicating. But I would welcome anyone else's input. Many of you may have participated in more water board proceedings than I have, or at least more intimately. So I'm open to different ideas. Mr. Jacobs.
But my suggestion, well, so I have reviewed the testimony that's been submitted, and a lot of it is really complicated. And while it's on similar topics, some of it, it's different in certain ways. So I don't know, but ultimately in my mind, it's up to you. Whatever you think it works best, we should do.
Well, on that, so proceeding witness by witness, direct and then cross, does anyone else have an opinion about that, about how that would go? Or is there a preference for cross-examining by panel?
Ms. Kinsey, I think we would prefer to cross-examine at least our two engineering witnesses together because their testimony is somewhat interrelated. I think for the others, it's probably less important, but I do tend to agree with you. It's typically more efficient.
Mr. Hughes, I saw you go off mute. Do you have something you'd like to add?
Yeah, I was thinking that maybe in line with what Mr. O'Brien just said, in that it may be situational, so to speak, in terms of the witness's testimony. The engineering aspects, there may be crossover between the two witnesses, and so taking them at the same time would be appropriate. At the same time, picking on, say, a Steve Haugen, there may be things that are unique to Steve Haugen that I think would be lost in a panel approach. And so I really think it's kind of a combination of the approaches I think would be best.
Okay. I can understand. That makes sense to me. Is we can either, well, I guess I asked in the second amended NOIs for a proposal on this. So maybe what I would do is ask for your proposal about how your witnesses be presented and cross-examined. And then if anyone has any, the other parties have objections to the proposed ordering, we can deal with that, and we can do this to some extent on the fly. That makes sense to me. I understand that some of this complicated testimony, it may really make sense to have the cross immediately. That Mr. Jacobs, I heard you on that one. I anticipate that may be helpful, but I want to run this as efficiently as possible. So does that sound appropriate, that I would hear your proposals on those second amended NOIs? If there are any objections, I'd be open to hearing that either in advance of the hearing or as we come to each party's witnesses.
I think that sounds like a good approach.
Okay, good. Let's do it that way.
Lindsay?
Yes.
I have a question related to
I'm trying to find you. Mr. Donlan, I see you.
Oh, I'm sorry. Did I interrupt?
No, not at all. Please, Mr. Donlan.
Related to the panels, on page 3 of your order, you, at the bottom, the last paragraph, you discuss friendly cross-examination. I think given the complexity of the testimony, it's going to be very difficult to determine friendly cross-examination from cross-examination intended to extract useful information. And I also think it's probably premature to assume alignment of all of these parties on all issues.
Mm-hmm.
How do you intend to decide whether a cross-examination is friendly or authorized under paragraph, the last paragraph on page 3?
Thank you. It's a good issue. I guess from my own experience, I'll let you know what my background experience is based on my experience in participating or advising during the water fix proceeding, which many of you were involved with. I saw what I thought was a lot of use of cross-examination as essentially redirect of testimony, and I just wanted to try to avoid that issue. I understand that not all of the parties in this case are aligned. To some extent, I wonder if, you can correct me if I'm wrong, but I wonder if on phase 1A, there may be somewhat more alignment on more clear lines, but I realize this testimony will probably be brought in for later phases of this proceeding, and so you may have an interest in examining certain issues. Although I will say, as we move forward in this proceeding, we get to, for example, phase 2, there, I think, would be other opportunities to cross-examine these witnesses on particular issues. So it's going to be something we do on the fly, but it's more a general request for your participation in allowing the parties to produce their own direct testimony and not to use cross-examination essentially as an opportunity to redirect the witness in a way that really the party is perfectly well situated of doing for themselves. Does that make sense?
It does, thank you. So it will be decided in much the same way as the paneling issue.
Yeah.
Ms. Kenzie, this is Sam Bivens. As long as we're on the subject of cross here, I'm curious about how the mechanics of using documents in connection with cross-examination are going to work, and specifically if there's going to be, a staff member who will be putting up exhibits, and then for documents that may not be submitted formally as exhibits, but could be used on cross-examination, who will be responsible for putting those up and screen sharing and
yes.
like.
Yes, thank you. That's a good point. In the past in our office, and I didn't have that in my notes, so I really appreciate it. In the past in our office, we have maintained the control of the screen share through our office, which would mean, and Ms. Mullen in our office has done a very good job, I think, so far, of being able to pull up exhibits quickly, but it doesn't mean that you would need to have your exhibits ready to go and probably submitted to us either by email or through the FTP site in advance of your cross. It doesn't have to be much in advance of your cross, but available so that Ms. Mullen will be able to pull those up on a screen share basis. And like I said, she's been very effective in the past. This has worked well. If we get into this and we find it really needs to be done another way, I mean, I think we are all, I'm very fortunate to have very professional parties in this proceeding, and we could modify that, but I would like to proceed that way, and that should work. But thank you. That would require all of you to make your potential cross exhibits available to Ms. Mullen, probably now that I think about it, through the FTP site, because they may be large documents. And then she, as you need them, can pull those up for you.
Thank you.
Sure. And I should say the same would be true with the direct testimony and exhibits needed that way. Ms. Mullen will control the screen share and will pull those up as needed and can flip through as needed. I have next on my list to talk about the additional hearing dates and then also rebuttal, but I'll pause here. Is there anything else on cross that we've talked about, the order of proceeding, though thus far, having not gotten to rebuttal yet? Any other comments? I'll move on. I wanted to thank all of you for submitting your availability after the last time we talked, and your witness availability, so that we could schedule additional hearing dates. I assume we'll need them. I wanted to talk through a few specific issues about availability. I believe on June 17th, so June 17th, we scheduled the afternoon because our office has another matter scheduled for the morning. We can only do one at a time so far. But I believe, Ms. Moritzen, you indicated you would be unavailable on June 17th. I just wanted to talk through that in advance to make sure I understand it and can schedule accordingly. I wanted to know, Mr. Keel, whether you'd be available to represent Tulare Lake Basin on June 17th. For example, if we were hearing rebuttal testimony from Semi-Tropic on that day. Otherwise, we could order this differently, but I just wanted to get input from both of you on constraints on your availability for the afternoon of June 17th.
While I am available, Ms. Moritzen is not. And when we were evaluating this, we didn't think that as a team, we would be able to represent our client on that date. It's possible.
The preference would be to, I mean, so this is what I'm thinking, is that it may make sense to order things differently. I don't know that Semi-Tropic, it's sort of somewhat logical that Semi-Tropic would present their rebuttal testimony first, but that's not necessarily what we need to do. Given this caveat about friendly cross, would you be opposed to the hearing proceeding and hearing from parties other than Semi-Tropic on the afternoon of June 17th so we can utilize that day?
I think initially, I think that would be appropriate if it were one of the KRWA member units providing testimony, that we would have sufficient coverage for that situation.
Okay. So we are going to have to do this on the fly a little bit. What I will say is, if we can avoid the afternoon of June 17th, we'll do that. So we'll try to do that and accommodate that. If we can't, if we can't accommodate that, we may want to restructure so that Semi-Tropic either puts on testimony on June 4th, which I'm going to talk about in a minute, or June 18th, rebuttal testimony, I should say. And I want to hear from all of you on that. Another issue I noted is that the McMullen area GSA, I believe, had identified a potential rebuttal witness who is unavailable on the 18th. And I wanted to confirm that, and then confirm that this witness would, at least to your knowledge, be available on either the 17th or June 4th. I'm turning back. I don't have this all in my mind. Who is my representative from McMullen?
Ms. Kinsey, Robert Donlin here. I need to defer to my colleague, Sean.
You're looking at your, no, I had a spreadsheet that I was referring to. Well, shall we pause for a moment and get back to that?
And can we come back to that? I was just double checking my notes on that. I apologize.
I think I have it up here. I can even tell you that Ms. Palmer, I think, was identified as a potential witness who was not available on June 18th. And we can circle back to that because I think we're going to have about to have a robust conversation about when we start rebuttal. So the timing of rebuttal, we have 4.5 days right now for this hearing. I don't know, of course, at this point, and you don't know how much rebuttal to testimony will be proposed to put on. I think it's possible that we could finish the case in chief portion of the hearing before the end of the day on June 4th, in which case I think it makes sense to get started on rebuttal testimony if we have the time to do so, to move this along efficiently instead of leaving off the rest of the day on June 4th. Now, if rebuttal testimony, when those exhibits come in and it looks like it's pretty limited, it looks like we can get through it in a day. That'd be hopeful, it's aspirational. Then I'm perfectly happy to leave that off. If we get through our case in chief, it looks like we can finish our rebuttal in a day. Then let's leave off where we are on June 3rd or 4th and come back to that on June 18th. But if it looks like we may need that extra time, which I suspect we may, I do want to be prepared to move forward with rebuttal on June 4th. And I think it would make sense ideally to have Semi-Tropic start us off with that, at least the way I'm thinking about it now. And I wanted to get your input on how you envision this might go. I realize there's some limits because we don't know how much rebuttal there's going to be. I appreciate early on that all of you seem to have submitted a lot of your information and testimony and exhibits in the case in chief. So I'm not quite sure what to anticipate, but I would appreciate any input on this. We can do it on the fly, but I'm trying to give all of you as much notice as possible so that you can plan accordingly. So if you have any comments, I'd appreciate that. I see Mr. O'Brien, you went off mute.
Maybe I'll take the lead on this one, Ms.
Great.
Kinsey. I don't expect extensive rebuttal, but based on discussions we've had, I think we'll probably have three rebuttal witnesses with written testimony, obviously. And I would think we would be looking at somewhere around an hour and a half for the rebuttal direct testimony, and then whatever cross-examination there is. So I think the idea moving forward on the 4th makes good sense to make full use of our time, and hopefully we could conclude the Semi-Tropic rebuttal on that date.
That would be, I think, an ideal goal to keep us moving along. Are there any other comments on that point so far? Ms. Grady.
Ms. Kinsey.
Yes.
I just wanted to let you know, I confirmed with our witness while we were talking now, just to double check, because I apologize for not checking in with her before. She was trying to see if she could make that date available. She said she would prefer the 4th or the 17th, but could juggle things and be available on the 18th if needed. So we will.
Oh, I'm sorry. So maybe I missed, or confirm for me. I think I had in my notes that she was unavailable on the 17th, but was available the 4th or the 18th.
She has just confirmed with me there were some scheduling issues going on and has now advised me that she is certainly available on the 4th and the 17th and could work to move things around to be available on the 18th if needed.
Okay.
So I apologize for the confusion on that point. We've been trying to pin down details.
I'm sure. But no, I thank you for that information, and I will try to keep that in my mind as we go forward in the timing of this. But please don't hesitate to remind me if this comes up as an issue. Are there, so as things stand, I would say, please be prepared if we can to go forward with Semi-Tropic's rebuttal witnesses on June 4th. And hopefully we can get through some of those. Are there any other comments on rebuttal or the timing of rebuttal? Thank you. Thank you. Thank you for your input on this. We'll see how this goes. We can do this. Next on my list is Damon Hess. I think where I left off was the upper irrigation districts had identified Mr. Hess as a potential witness. And I was just wondering about an update from you, and then whether you've had conversations with Mr. Petrozelli or others from the Office of Enforcement about whether or not you're still planning to call him and how that would work if you are.
Thank you. We do intend to call Mr. Hess. I have spoken through Mr. Petrozelli, and the request that's been made from Mr. Hess is that if possible, we can confirm his date and even somewhat time. And if we can do that today, we will get out a subpoena and just make it official. But that's where we're at.
And that reminds me, thank you so much, Mr. Jacobs. That reminds me, I think I left off where I said, well, I think it makes sense to do Semi-Tropic first and then either the upper irrigation districts or KRWA. I'm not sure which one. Is there a preference? Do you think, does it make sense after we hear the witnesses from Semi-Tropic, should we move next to KRWA or the upper irrigation districts that would be on June 2nd, I believe, hopefully, maybe.
I don't have a strong preference. Joe, I'm going to defer to Joe if he wants to go first.
Yeah, I think that as I sit here today, I think my preference would be that KRWA proceed first. I think we can establish a fair amount of foundation that the other folks can build upon. So as I sit here today, I think it would be KRWA going first.
Okay. And then the upper irrigation districts. That said, we can put Mr. Hess in where it's convenient to some extent. Mr. Petrozelli, do you have any comments on what would work best for?
So we haven't identified a particular day. We just want to be sure there is a particular day so that Mr. Hess doesn't have to keep his schedule open for all of the identified hearing days.
Mm-hmm.
As I'm sure you would understand, he's extremely busy with drought. The entire division is busy with drought, and his involvement in this proceeding not only involves him, but it also requires involvement from his supervisors, as well as legal counsel. We're not a party in this proceeding. We didn't file a notice of intent to appear, and we haven't been closely following this, and we weren't actually aware that Mr. Hess might ask to be involved until about April 23rd-ish, 26th-ish. And that was the first conversation we ever had about it. However, we did talk about it, and Mr. Jacobs we did talk about it with Mr. Jacobs, and he agreed that we would like to have a specific day scheduled. Mr. Jacobs also indicated that the only topic he believed he required testimony from Mr. Hess on was about the January 2020 letter. So we would also like to be sure that the scope of prospective testimony is limited, because that also affects the extent to which Mr. Hess may feel a need to prepare for this, as well as the scope of potential questioning. And finally, Mr. Jacobs indicated that he didn't believe any more than an hour would be necessary for Mr. Hess's appearance.
Thank you. Mr. Jacobs, I'm sorry, did you want to respond to that?
Well, and when I said an hour, I think an hour total. Like I think our direct might be 10 minutes, 15 minutes. So, and the scope, as Mr. Petrozelli indicated, is limited to the letter email exchange in early 2020.
Thank you. So this is what I'm thinking. What I would think makes sense is the morning of June 3rd, first thing in the morning at essentially 9 a.m. when we get started. If Mr. Hess would be available to make that the day and time, hopefully we'll break at some logical point on June 2nd. And then we'll get in Mr. Hess's testimony and then pick up wherever we had left off on June 2nd after that. That way there'd be a specific time and we'd hear from him right off in the morning. Does that make sense to you? If anyone has a comment, but first, Mr. Petrozelli, does that make sense to you? Would that satisfy your concerns? I'm sorry, you're on mute.
Yes, it does. Thank you.
And Mr. Jacobs, does that make sense to you?
Yes, thank you.
Ms. Kinsey, lest my silence be interpreted as agreement, we do intend to object to the testimony of Mr. Hess on relevance grounds.
Okay.
We think the whole purpose of this hearing is to determine the merits of the complaint, and what Mr. Hess did or didn't do, we don't think is particularly relevant, but we can take that up at the hearing.
Thank you. Noted. Are there anything else we need to talk about or any other comments on Mr. Hess's testimony and appearance? Are there any other, I think I've exhausted my list of things that I had identified, and thank you for talking through many of them. Are there other procedural issues we should discuss today before we talk about whether or not to set another pre-hearing conference?
Yes, Ms. Kenzie, this is Sam Bivens for
Thank you.
Semi-Tropic. I have a number of them, not too many, but a few. One is, as long as we're on the topic of Mr. O'Brien's last statement, how do you want to handle evidentiary motions? Should those be handled in the ordinary course of the hearing, the speaking motions? Would you prefer motions in limine, written motions in limine rather? I'm agnostic on the procedure. We certainly don't want to burden you with paperwork, and we're happy to do what you think is best and most efficient in terms of evidentiary motions.
I think to the extent Mr. Hess is a little different, we'll set that aside, but to the extent you can anticipate what those motions would be, motions in limine in advance of the hearing in writing, I think would be quite helpful for me. And we may be able, if we can, we either have time to address and dispose of those in advance of the hearing, or at least I would have some of the information in advance of the hearing. We can talk about whether or not there should be deadlines for that. And I also should say, I don't think that would be helpful, but I'm not at this point planning to preclude in any way oral motions on evidence during the hearing. Those could be raised as well. It's just that it would be helpful, particularly if it's a more complicated objection, to raise those in advance. I'd appreciate it so that I could think about those in advance, and then other parties would have a chance to respond either in writing or orally at the hearing as well. Do others have comments on the best way to handle evidentiary objections? I mean, I think likely I will try to respond to those in writing in advance of the hearing, but it may also be that we end up dealing with those orally on the fly during the hearing, depending on what they are.
Ms. Kinsey,
Yes.
I think it's a good idea to allow the advanced filing of the written motions in limine. In reviewing the Semi-Tropic testimonies, I believe we'll be filing some of our own. So I think it would be a good exercise to address as much of that in advance of the hearing.
Yes. So I think the bottom line would be I welcome and will receive those motions in advance of the hearing. I think I put some kind of, please respond if there are procedural motions, please respond within a few days, but please, if you can, respond to those motions within, if the hearing doesn't come up, but within 5 to 7 days. I won't plan to rule on them before I have the opposing parties have a chance to respond, unless it's pretty clear to me. That would be helpful. I sort of hesitate to set deadlines because I will also entertain oral motions, and really having it in writing one way or the other. I don't know. Is there a preference for deadlines? Do we want to have a motion in limine deadline before the hearing?
Yes, I think we would speak.
Yes, you do. Good. You like deadlines. Okay, let's have a deadline.
I like to know what I'm getting into.
Yeah, that's fair. Okay, so what do you propose for a deadline?
Let's look at that.
That's on the fly. I'm looking at my
calendar here. If we're starting on the 2nd and you want a response let's just say within 5 days of the filing of the motion, perhaps we ought to look at Monday the 24th as a potential deadline or thereabouts, and that way at least there can be a response filed within 5 days before the hearing actually begins. If you're able to rule on those motions in advance of the hearing, I'll be impressed. But certainly they might be able to be dealt with at the beginning of the hearing.
Well, I'm counting here. Shall we do the 24th or the 21st for the motions? Because then if we do the 21st, we could set a deadline of the 28th for a response. So it's actually 5 business days instead of, it is Memorial Day weekend. That's part of why I'm counting here. It's Memorial Day weekend in the intervening time. Let me put it this way. Does anyone have any objections to setting May 21st? That's only 10 days from now, but you've had the exhibits. May 21st as the deadline for objections to motions in limine to case in chief evidence. So not obviously not rebuttal, but case in chief. And then I will say I will not rule on those motions. So you're welcome to file responses. I will not rule on them until the first, but more likely during the hearing. So in other words, if you want me to read your response, get it in by May 28th. Does that make sense? Are there any other comments on that? And I know, Mr. Bivens, you probably have more things, but I just want to dispose on this issue. Are there any other comments? Okay, great, thank you.
Just two more items. The first one, perhaps being a larger item than the second one, but I wanted to talk about written opening statements and closing briefs generally, and also the deadlines for submitting them. So I understand from the hearing notices that the parties may submit a written opening statement. I'm curious about when those ought to be filed. And then on closing briefs, I think at a past pre-hearing conference, maybe it was the first one we all attended together, it sounded like the parties agreed that closing trial briefs would be appropriate in lieu of closing statements at the hearing. It'd be helpful to have a deadline for those. And then relatedly, I'll just note that the Tulare Lake Basin Water Storage District filed as their very first exhibit an opening brief that goes well beyond the bounds of an opening statement, certainly. And I'm curious if that's something that's going to be allowed. We'd certainly submit our own opening brief on both legal and factual issues. Alternatively, if that's not something that's going to be helpful to the hearing officer, then we'd ask that exhibit be excluded or withdrawn, and with no prejudice submitting an actual opening statement.
I think if I heard you right, and I don't think I've gotten that far in the exhibits, it was Tulare Lake. So Mr. Donlin, do you have any comments on, it sounds like the exhibit and whether or not it was intended as an opening brief, I
think that's for Mr. Keel, Ms. Kenzie.
Oh, I'm sorry. Apologies.
We did submit an opening brief. Semi-Tropic is free to submit any objections if it has evidentiary objections. We thought it was appropriate describing our view of what this proceeding is, put context for all the evidence we're putting in. This isn't a customary hearing. There's no existing pleading on file. We didn't really know what we're shooting at, so we thought it was helpful to define why we're all here.
Yeah, what I'm thinking through, this is an interesting question that I hadn't thought about. What my initial response is, well, that's what closing briefs are for. On the other hand, I can understand, and maybe you may think it would be helpful for me to think about these issues before we embark on hearing testimony and looking at the exhibits and cross-examining and asking questions of all these witnesses. I'm certainly not opposed to reading opening briefs, but I would want to put some kind of page limit on them so that it's fair and so that I can do it. Are there other parties would be in favor of submitting an opening brief in writing? Are the things you think it would be helpful for me to understand in advance of the hearing and hearing from your witnesses?
I think that would be helpful, Ms. Kinsey,
Okay.
Not unlike the standard trial brief, the roadmap as to where we're going. It was interesting submitting all the testimonies and whatnot, because you really didn't have the thread that brought them all together. And this goes back to Mr. Keel's comment and the desire to provide that roadmap as these testimonies are going in. So I think that would be very helpful.
I agree.
I'm sorry, Mr. Jacobs, please.
I agree with that sentiment.
Great. And I'm thinking this through. I think the opportunity to respond, I'm sure some of you will have disagreements about what's stated in the opening briefs. On the other hand, I think the opportunity to respond to those would be in the closing brief. So I guess my initial reaction to that would be just to have your opening briefs in by the 28th. I can read them. I'm not, you know, you can anticipate from my statements that I don't have truly exciting Memorial Day weekend plans. So I can read them, and that would give me a chance to do so. Is there a comment on that date as a deadline and also appropriate page limit? My initial thought is certainly no more than, well, how many pages do you need? I would say no more than 15. I'm thinking about 10, but how many pages do you think you need? Are there any comments on that?
Well, I want to say, I think the Tulare Lake Basin Water Storage Districts ran to 17 pages, not including the caption. I don't anticipate that we will file that lengthy of a brief, but we'd certainly like the opportunity to do so if we need to.
Well, let's make it 15 pages. Mr. Keel, if you can modify it accordingly, you have a chance to modify and resubmit accordingly. You probably get it into 15 pages, but let's put a 15-page limit on the opening briefs, please, so I can get through them all. And if you're overachievers and you get those in sooner than May 28th, that would be super, but not required.
Perhaps this is an overly picky request, Ms. Kenzie, but can we not have the brief marked as an exhibit and part of the evidentiary record? That seems like it might confuse the record at some point.
No, I think, thank you for that point. I think that's perfectly appropriate. It shouldn't be marked as an exhibit. It should be a submittal. You can still use the FTP site to submit them, but please, Mr. Keel, if you would mark it simply as an opening brief, not as an exhibit, identified exhibit, we won't be moving it into evidence. I think that makes sense to me. I think that's appropriate. Are there other comments on opening briefs? I think Mr. Bivens, you may have one more thing, but other comments on that? And I have this May 28th deadline for opening briefs, 15-page limit.
Yeah, just relatedly for the closing trial groups, when should those be submitted? Do we want to set a deadline for those? I think it would be
Yes, we might as well, because we know or at least we anticipate we can change it if we have to, but we should be wrapping up on June 18th. And then we can move accordingly from there. Let's see. Excuse me while I flip through my calendar here. So I'm initially looking at July 6th. That would be roughly 2 weeks after June 18th, with a few additional days. I'll be out of town over some of that period, so there's no sense getting it in before July 6th when I can address them. But I would look at July 6th and the same thing, a 15-page limit. Are there any objections to that?
If we could if we could move that out, possibly to Friday the 9th, that would be helpful. I have some conflicts myself.
No, and some of you may, I think it's perfectly appropriate to do things like go on vacation in the summer. So if you do have a conflict, I'm open to that kind of thing.
I appreciate that.
Yeah. So July 9th, 15-page limit on closing briefs. Great. And Mr. Bivens, was that all of your list?
One more item, very simple nuts and bolts item. I know the hearing notice provides for the parties may hire their own court reporter to transcribe the proceedings.
Yes.
The State Board won't be providing a transcript. I guess my question would be, sometimes court reporters need to ask to have things repeated or things spelled out. Will they be able to appear on the Zoom, or are you anticipating that they'll simply transcribe the archived live stream?
We haven't had, well, we've had one court reporter appear. They certainly will be welcome to participate by Zoom and ask if we can slow down, as is normal practice. I don't know the details of these things. I know on occasion it's helpful for the court reporter to have maybe other access to Zoom if they need to have their own recording or something like that. And we're happy to work with a court reporter in advance if they need access as appropriate to the, the internal meeting structure. I don't know anything about those things, but no, we certainly would support a court reporter participating, doing what needs to be done to make sure we don't speak at lightning speed, myself included. So please just let our office know in advance how we can help support that if that's something you're interested in doing.
Wonderful. Thank you. That concludes my list of items.
Great. Thank you. Are there others with other procedural items? All of these have been quite helpful. Thank you for bringing them up. Are there other issues we should address today?
Ms. Kenzie, I
Yes, please.
did want to clarify or ask for clarification that if or when Mr. Hess is called to testify, that I, will of course be permitted to, provide legal counsel for him and make as appropriate and make legal objections if he's when appropriate.
Absolutely, yes. And then should ask you, would you like to be added to the service list? Would that make sense so that you receive everything going forward
Yes.
that's happening in the proceeding?
Yes. Okay. Although I would remind you that since we're not parties in this,
Yes.
we don't closely track it, and looking at the, and it does look like there's a significant amount of, paper generated by this, so.
Yes, noted. But with the service list, at least you'll be notified. Although also our office, any of my orders go out to our Kings River FAS LIRIS list, and then also the general AHO LIRIS list. So that may be an additional way to make sure that you're alerted to any rulings and the like that come out.
Okay, thank you.
So that's not the general service list, but I'll add you as probably identify the Office of Enforcement as an interested party, or interested person, to clarify that you're not a party to the proceeding, but asking the other parties to include you in service on documents, at least going forward. And if at any point you care to be removed from the list, just let us know.
All right, thank you.
Thank you. So that leads me, if anyone else thinks of something, please let me know, but do we need another pre-hearing conference before the hearing? My sense right now is that we have covered a lot of this pretty carefully, and I appreciate that. And I think we're ready to go to June 2nd, at least based on what we've talked about today. Other issues may come up and we may want to meet again. And I encourage you to let us know, and all the parties know, if there's something that comes up and you think we need a pre-hearing conference. But my inclination would be to go and go forward and see you virtually on June 2nd. But does anyone think we do need another pre-hearing conference before June 2nd? On that, I'll say I will be issuing an order based on this conference today to memorialize what we talked about. If there's anything you see that you think doesn't reflect what we talked about today, please let me know. But that order will be coming out within a few days. And then other than that, based on our discussion, I will see all of you on June 2nd virtually. Thank you for being here today. This was quite helpful. And this pre-hearing conference is adjourned. Thank you very much.
Thank you.
Thank you.
Thank you.